Today we are unpacking a seismic change to UK ILR and immigration policy announced by Home Secretary Shabana Mahmood in late November 2025. The new earned settlement framework that, among other things, dramatically extends how long some migrants may have to wait for indefinite leave to remain in extreme cases up to 30 years. This is complex, fast-moving and already stirring fierce political and public debate. So in this video, I'll walk you through what's been proposed, who it affects, why the government says it's doing this, and what critics and supporters are saying right now. I'll also explain the immediate practical impacts for migrants living and working in the UK, and what to watch next in the consultation and parliamentary process. So, if you are new, make sure you subscribe to the channel and ring the notification bell for upcoming updates. The government has launched what it calls the biggest overhaul of the legal migration model in 50 years. At the centre of the package is an earned settlement model that removes the automatic route to settlement after 5 years and lifts the baseline qualifying period for most people to 10 years. On top of that baseline, ministers have proposed a sliding scale of waiting periods tied to behaviour, contribution and route into the UK. Those who are judged to have contributed more high earners, certain skilled workers, or people who meet enhanced integration measures could be fast-tracked in as little as 3 to 5 years. By contrast, people arriving through irregular routes, or those who claim public benefits, could face much longer waits. The government has said some people could be required to wait 20 to 30 years before they qualify for ILR. The official announcements and associated consultation papers set out these options in detail. So why now? The government frames this as fixing a system that it says creates perverse incentives and places strains on public services and communities. Home Secretary Shabana Mahmood has described long-term settlement as a privilege that must be earned, not an automatic right. And the proposals are explicitly designed to direct faster settlement to people who are contributing economically and socially, while penalising behaviour the government sees as abusing the system. The political context is important. Migration and asylum have become intensely salient issues, with pressure on Labour from voters and opposition parties to show it can get a grip on small boat crossings, irregular arrivals. Mahmood's team says the overhaul will reduce net migration and protect public services by creating stronger incentives for integration and contribution. What else is in the package? The proposals are broad. They include ending automatic entitlement to certain benefits and social housing for people who simply have settled status. The government proposes restricting these supports until citizenship in many cases. Temporary protection arrangements would be tightened and reviewed more frequently, and the period after which refugees can apply for permanent settlement looks likely to be extended substantially. Some announcements have referenced increases from 5 years to 2 decades for certain groups. The Home Office has also floated a point-based contribution system for settlement that would reward volunteering, high English proficiency, high income, or meeting other integration metrics. There would also be targeted measures on family reunion, asset recovery to offset costs, and new enforcement levers for deportation and removals. These are draft measures at consultation stage, but they are wide-ranging and consequential. Who is affected immediately and who is protected? The government says existing settled status holders will not be stripped of the rights they already have. The changes are aimed at future applicants and people currently on temporary visas or in the asylum system. However, the consultation and the broader overhaul mean that many people currently living and working in the UK, including health and care workers and other public-facing staff, are anxious because the new rules would change the path they had expected to take to settlement. Employers and unions have warned that extending waits for settlement and restricting benefits could make retention of nurses, doctors and care staff far harder, even though ministers are also proposing pathways to speed settlement for certain skilled workers. The tension is that the government wants to both deter irregular migration and keep the door open for high-skilled talent. Balancing those objectives is politically and practically tricky. What has been the reaction so far? Responses are mixed but intense. Many conservative-leaning commentators and politicians have welcomed the tougher approach as necessary and overdue. Several opposition voices and charities, including refugee organisations and trade unions, have strongly condemned the proposals as punitive, potentially cruel, and likely to increase destitution and instability among vulnerable families. Legal experts warn of increased bureaucracy and complexity, which could slow down decision-making and create legal challenges. The consultation window is open for several weeks, and judges, human rights lawyers, and NGOs are already preparing submissions and litigation strategies. Expect parliamentary scrutiny and court challenges to follow if the government pushes ahead. Let's talk numbers and timelines. The government has published an official consultation and a command paper outlining the proposed changes, with the consultation period running into early 2026. Key elements include doubling the baseline ILR qualifying period to 10 years for most routes, with potential extensions to 20 or 30 years depending on route and behaviour. Fast-track options for high earners and entrepreneurs, potentially as short as 3 years, are also being proposed. The consultation is the formal mechanism for input from stakeholders and the public, and ministers stress that these are proposals, not final law. That said, the wording in the government's published documents is already quite precise, and the political will behind the package suggests substantial parts may move forward without major dilution unless there is decisive opposition. What does this mean for ordinary people living in the UK now? If you are on a skilled visa and you earn above certain thresholds or meet enhanced integration criteria, you may benefit from faster routes the government describes. If you arrived via an irregular route, or if you rely on means-tested benefits, you could be pushed to the back of the line for settlement. For families, the new limits on family reunion and tightened rules around benefits could make life much more uncertain. For employers, especially in health and social care, hospitality and agriculture, there is fear that extending settlement horizons will harm recruitment and retention, making workforce planning even harder. For local services and councils, the proposed restriction of housing and benefits until citizenship raises immediate ethical and practical dilemmas about how to house and support people in need. How likely is it to become law? The government controls the legislative timetable, and the consultation is the first formal step. But these measures touch on human rights, international obligations, and settled rights, so legal challenges are likely. Politically, Labour's majority gives ministers room to legislate, but internal party divisions and public backlash could force changes. Parliamentary committees, legal reviews, and sustained campaigning by NGOs could influence the final shape. The bottom line is that while some elements like raising the baseline qualifying period look likely to proceed in some form, the extreme end of a 30-year wait for certain groups may be contested and amended before any final legislation. Still, the headline has already shifted the landscape and will shape public debate and future policy choices for years. What should migrants and employers do now? Keep calm and get informed. Read the official consultation documents, follow reputable legal advisors and immigration NGOs, and if you're an employer, start contingency planning for recruitment and retention. If you or someone you know is directly affected, get specialist immigration advice promptly. The rules, if enacted, will be complex and transitional arrangements are likely to matter a lot. For campaigners and legal practitioners, the consultation is a crucial moment to submit evidence and argue for protections for vulnerable groups. The immediate window for influence is short, so engagement now matters. Finally, what are the broader implications? Beyond individual cases, this proposal signals a major philosophical shift in UK migration policy, moving from relatively predictable, time-based paths to settlement towards a conditional, contribution-centred model. That has consequences for social cohesion, labour markets, and the UK's international reputation on asylum and refugee protection. It also shows how migration policy is increasingly shaped by domestic political pressures and the need to respond to irregular migration, even at the cost of complicating legal routes for people who simply want to settle and build a life here. Expect this to be a dominant policy debate through 2026 as the consultation, parliamentary scrutiny, and legal challenges play out. If you found this helpful, like the video, subscribe for updates, and share this with anyone who needs to know migrants, employers, or friends in policy and law. I'll be watching the consultation responses and any parliamentary moves closely, and will bring you follow-up explainers as the story develops. Leave questions or experiences in the comments and I'll answer what I can. Thanks for watching, and I'll see you next time.